Hi everyone, welcome to our webinar on buying a business and how to minimise your risk. My name's Sarah Aldersley, I'm a practice leader in LegalVision's corporate team, and I'm joined today by my colleague Michaela O'Connor, who's a senior associate in our corporate and commercial team. Just before we begin, we've got a couple of quick housekeeping items. So you will receive the recording of this webinar and the slides in your email afterwards, so don't worry too much about making frantic notes. If you have any questions, please put them in the chat box and then we'll get to them at the end. And you'll also be sent a feedback survey after the webinar, so it's really useful for us to get some feedback, so please do fill this in. You'll also be eligible to receive a complimentary consultation with our legal team. So if you'd like one of these, please just leave your contact details in the survey that appears when the webinar is over. Great. So today we will be discussing the first steps to be taken as a buyer of a business, the purchase process, due diligence, the contract stage, settlement/completion, and then we'll move on to the Q&A at the end. Perfect. So yeah, as I said, if you do have any questions, just submit them using the chat function, and yeah, we'll get to them at the end of the webinar. So I'll hand over to Michaela now to speak about finding the right business to acquire and the initial steps that you should be taking.
Thanks, Sarah. So I think one of the first things you should think about if you're looking for a business to acquire, or if you've already found a business you think would be suitable, should be to conduct some initial due diligence on the business. So this is to ensure that you know what you're buying and where the value of the business lies. If you haven't received an information memorandum about the business from the seller, then you should firstly request one, go over it in detail and ask questions. You need to also consider if the business is going to be suitable for you commercially, legally and financially. This means that your second step should be to engage specialists who can help you determine if the business is right for you. This usually includes a business advisor, accountant or tax advisor, and a lawyer who specialises in business purchases. These specialists can also advise you on the structure of the purchase, whether an asset purchase, which is what we also call a business purchase, or a share purchase is going to be most suitable for your circumstances. Today we'll walk you through the legal steps you can take to reduce your overall risk when acquiring a business. So I'll just head to the next, perfect. One of the major aspects of a business purchase is how you will be acquiring it. So when undertaking a purchase, you can either acquire the shares of the company, which operates the business, or the assets required in order to operate that business. These two options require a different type of purchase contract. Regardless of which way you choose to purchase, you should initially be looking to enter into what's called an exclusivity agreement. This will ensure that the seller cannot negotiate a sale with a third party for a specific period of time. You should also consider whether you would like to undertake a formal valuation if you haven't already agreed on the price, and also consider whether you wish to negotiate a non-binding offer, which is what we also sometimes call a term sheet, before negotiating a long-form purchase agreement. If you are putting together a term sheet, it would set out the commercial terms of the sale between the parties and should reduce any negotiations down the track on the agreed commercial terms. Whilst initial term sheets are generally non-binding, they will also give you some comfort over the deal and what you're expecting to purchase. You could also include an exclusivity term within this instead of preparing a separate exclusivity agreement. Even if you're not going to be entering into a term sheet though, it's still a good idea to still enter into an exclusivity agreement. This will ensure that the seller cannot sell the business or enter into any negotiations with another buyer for a set period of time. This will then give you a period of time in which you can be assured that a third party will not come in and purchase the business before you, and that you're not outlying any unnecessary expenses. For example, legal fees on the preparation of a sale contract. The seller may also require you to enter into what's called a non-disclosure agreement or confidentiality agreement prior to entering into a sale agreement. This may be a requirement of the seller to be signed before they will provide you with any confidential information of the business that you're going to be purchasing, such as any financial information that you might request as part of the due diligence process. As previously mentioned, you should also be conducting due diligence on the business you're acquiring, which includes financial, commercial, and legal due diligence. Sarah, I'll hand over to you to go further into the legal due diligence process.
Thanks, Michaela. So what is a due diligence process? So really, at its core, it's a formal process where an interested buyer will make inquiries about the business it's looking to buy, and this includes financial, legal, and other operational matters. So the purpose here is to flush out information to make sure that the buyer is armed with as much information as possible before completing the purchase, and also to just validate the representations that the seller has made about their business. So, if they're saying it's squeaky clean, making sure you've gone in and got all the information to make sure that is the case. It's never really a one size fits all, so the due diligence that you will undertake will be scalable depending on the specific nature and size of the business. So the due diligence process will also identify both known and unknown risks so that you can create a plan to overcome them. So this might be seeking contractual protection from the seller, renegotiating the price, or just understanding how you can fix any issues after completion. It will also assist in determining the value of the business, so whether or not the amount that you've offered to pay actually stands up against what you're going to be buying. Also, matters identified during the process can be discussed with the seller and used in deal negotiation. So really importantly, by just being aware up front of exactly what you're buying, it will help to avoid any post-acquisition shocks. So some of these shocks could be things like failing to extract value from the business after the deal is done. So, if you didn't carry out any DD, you might buy a business thinking you know what you've bought, and actually then stuff starts going wrong. So you're not kind of comfortable that the business you're buying can be something that you can add value to. Coupled with this could also be the inability to transition and integrate the business after acquisition. For example, if you already own a business and you're buying another one to add on, and making sure that you can actually integrate the two properly after completion. It tends to be things like IT, tech stacks, things like that, making sure that you can actually make it work together. Also thinking about your key staff, your customers, your suppliers, and making sure they're not lost after the acquisition. Also just being aware of what liabilities does that business have or company have, depending on how you're buying the business, and making sure you're completely aware about what you're inheriting, so there's no kind of surprises after completion, and perhaps there could be a large tax bill you weren't aware that needs to be paid. If any issues are to eventuate, then that could also end up resulting in a disconnect between your planned and your actual cash flow. So you might have a risk that you need to take some unplanned acquisition funding to help sort you out after the deal. So you want to sort of avoid this scenario. So whilst you may be able to carry out commercial due diligence yourself, for example, contacting customers, speaking to employees, typically as a buyer, you would instruct a specialist accountant to undertake the financial due diligence and also a corporate lawyer to undertake the legal due diligence. So each specialist should approach the process in a systematic way and provide a clear report of their findings that will highlight the key risks that they identify with the business and then also propose solutions to mitigate this risk. So from a legal perspective, it will depend on the business or the company, but there are always key elements to consider. So these include things like corporate reviews, so looking through company's house records, company registers, articles of associations and shareholders' deeds, conducting litigation searches. We can also carry out IP searches, also looking at employment contracts or perhaps just the contracts of key members of staff. Also looking at any material contracts, so things like customer agreements or supplier agreements, just to make sure if there are any red flag items that you know about them. Also, if the business uses T's and C's, we'll have a look at those for you to make sure that they are kind of protecting the business as much as possible. And also quite a big one can be property leases. If the business is operating out of a premises that's leased, making sure that lease is reviewed. So why are we looking at all of these things from a legal perspective? Well, we're trying to focus on protecting the value of the business for its future use. So making sure you know what you're buying and you're buying something that's going to work. So, for example, are the key client contracts actually locked in? Is there a written agreement in place with the customers? What are the termination rights under this contract? Is there a chance that customer might be able to terminate because of this sale? And if so, making sure you've got their consent to the sale so that doesn't happen. Excuse me. Is the business's IP protected? So what IP rights do they have? For example, if they have a trademark, have they actually registered this properly, or is it kind of an unregistered IP right? If they're using a domain name, which obviously most businesses will, is that name actually registered in the company that you're expecting it to be? Or sometimes you find founders that set up the business before they set up the company, that domain name might be in their individual name still, so that needs to be transferred over. Also, if you've got any really key IP that's being created by, say, a contractor or perhaps an employee, are there agreements in place that actually transfer that IP to the company? Again, just making sure that it is the company that's selling you the business or who you're buying through buying their shares, that's the entity that owns that IP. Are you going to be retaining key workers? So do you require any specific people after completion to enable you to continue to operate the business? And that includes the seller themselves. So they're going to be staying on after completion. So you might want to look at their employment contracts, make sure they're up to scratch. If not, get those amended, noting that you do need to sort of honour any employee entitlements pre-completion. Also the location. So if that location is really key to your business, and for example, it's a leasehold property, making sure that there's sufficient term left on the lease, you're not going to get kind of kicked out 6 months after completing, and also just making sure that you understand what the terms of that lease are. When's the next rent review going to be? What are your obligations when you exit the lease? Is it a full repair lease? So ultimately, really, you want to make sure that the big picture of the business, when you're factoring in all of its assets, all of its liabilities, equate with the purchase price that you're willing to pay. So knowing what issues the business is likely to have will also then inform what warranties and indemnities that you're going to ask the seller to give in the sale agreement. So for example, if you identify the company doesn't actually have any written agreements in place with its key customers, so the seller says, we just kind of speak to them on email or put in purchase orders whenever, and these are the terms that we've agreed verbally, you want to make sure that that is true. So getting a warranty from the seller that everything they've disclosed to you about that verbal or ad hoc arrangement is actually true, and they're not aware of any other matters that could potentially lead to a dispute with that customer. Equally, if you identify specific risks, so for example, if an employee had brought a claim against the business which is ongoing, that's a circumstance where you might ask for an indemnity. So that's where you know about the risk. You don't want to obviously have that coming up against you when you're the owner of the business. So you'd get the seller to kind of reimburse you for any loss that you might suffer as a result of that particular claim. So that's due diligence in a nutshell. I'll hand back over to Michaela to talk you through more of the contract stage.
Thanks, Sarah. So the next natural step after the due diligence stage is actually preparing the contract, so the purchase agreement. Usually the buyer will be responsible for drafting the contract of sale, whether it be a share purchase agreement or if you're going down the route of a business asset purchase agreement, but sometimes the seller will provide the first draft. Regardless of who is preparing it, some of the key legal protections that should be included in the sale contract are warranties, indemnities, which Sarah just touched on, in order to protect you from unknown and known risks that have become known during the due diligence process. Sometimes you might also require a personal guarantee from a seller in instances where there are particular concerns around the business that you're purchasing. Another protection to consider including is what we call a restrictive covenant, to restrain the seller from the sale, following the sale, from setting up a competing business or poaching your employees or customers. You could also look at including earn-out clauses, retention payments, escrow arrangements, and purchase price adjustments. And if you're required to pay a deposit, then you should be limiting when this deposit can be retained by the seller. And that would be set out in the sale contract as well. You should also consider whether a clause should be inserted around any notification or third-party approvals required for you to continue operation of the business. For instance, notifying customers of the change in ownership. Another key consideration is employees. So you really should be getting employment advice if there are employees involved in the business. There's a regulation called TUPE, so TUPE, and this imposes obligations on employers. It's designed to protect employees if the business in which they're employed changes hands by ensuring that their terms and conditions are upheld under that new employer. So it's really a good thing for you to have an understanding of TUPE if you're looking to buy a business in order to protect you from any potential claims. It's highly recommended that you have your business lawyer review or prepare the sale contract on your behalf to advise you on the terms that need to be included in order to protect you in your particular circumstances. Sarah will now go through the settlement process, which comes after the contract stage.
Great, thanks, Michaela. So you sometimes hear this called settlement, sometimes completion. They're really just interchangeable terms. So completion is the point that the assets or the shares, depending on how you're buying the business, will change ownership from the seller to the buyer. So this can be the date the contract is signed, but often it's actually a date in the future to allow time to satisfy what's called conditions precedent. So the stages would then be that you sign your sale contract. At that point, both the parties are locked in. They will be selling the business or buying the business, depending on which way you're looking at it from, as and when the conditions are satisfied. And then you complete when those conditions are actually satisfied. So some examples of these conditions are things like completing the due diligence. So we actually normally advise clients to have this completed before they sign the sale agreement. It just gives them more certainty around the deal terms and means if you do need to negotiate anything arising as a result of your due diligence findings, you still have a chance to do that. But sometimes there might be a commercial reason, if it's a very rushed deal, that you need to sign a sale agreement to get that legally binding obligation in place and then actually complete your due diligence with a clause allowing you to pull out if it's not to your satisfaction. More commonly, it's things like the seller needing to obtain consent from third parties. So, for example, if you're doing a business purchase and there's a lease, most landlords will need to provide their consent for that lease to be transferred. You might also have some key customer contracts or key supplier contracts that have a change of control provision or restriction on assignment, so you do need to get their consent as well for you to keep that contract post-completion. But as the buyer, you might also be obtaining financing for the purchase, so you obviously want this to be a condition to having to complete. The seller may also need to secure the release of security interests over the assets of the target. And there may also be some key employees that you've found out through your due diligence process that you're not happy with the terms of their agreements. So you might want, for example, those to be changed before completion. And you'd put that as a condition precedent. So these conditions are normally for the benefit of the buyer. So it'll be the buyer's lawyers typically that will run the completion process. Depending on the size of the deal, they might put together a completion checklist, which sets out all the deliverables in the transaction document that need to sort of be checked off before you can actually complete. So as soon as that sale contract signed, and sometimes you can even get going a bit beforehand, the seller will address each of those conditions precedent to make sure that they're being satisfied. And the buyer, is required to also help out with this. If there's anything that they need to assist with, they will be required to do that. As completion gets closer, parties will normally have more frequent check-ins around how they're going with those completion conditions and sort of setting up a proposed date for completion. So that's kind of the build up to completion. And on the next slide, I'll be talking about what actually happens on the day of completion. So, most of the hard work should really be done by this point. The conditions precedent should be satisfied, but there may well be some documents that are yet to be provided that need to be provided at completion. For example, if you are getting employees to enter into new agreements, you want to see signed copies of those on the completion date. Usually there'll be a completion call between the parties. This is typically between the lawyers. You'll run through the checklist, make sure both sides are happy, that they've got everything, they've seen everything they need to see, and then you'll agree to complete subject to funds. So once that has happened, the buyer will then transfer any upfront payment to the seller. Often, again, if there's lawyers involved, that goes through the client accounts, and then the lawyers will agree that yes, completion has occurred when those funds have been sent. So on this day, you need to make sure the seller is delivering to you anything else you're expecting. So things like keys to any premises, any records that they're keeping in hard copy, passwords to any of their email accounts or social media accounts. So, at that point, you've got everything that you're ready to go from that date. Great, so that's kind of the full spectrum of what it takes to buy a business. So Michaela will just run you through kind of the key takeaways, and then we can move on to any questions that you have.
Yeah, definitely. So if there's 3 key takeaways that we want for you to take away from this webinar, the first would be that it's really important to conduct due diligence on the target business. So that includes financial, legal, and commercial due diligence. Whilst you might conduct the commercial due diligence yourself, it is advised that you engage a financial advisor or accountant and a lawyer to assist you with the financial and the legal side of things. It's also important to have a sale agreement that's drafted to the particular circumstances of your target company and the terms of sales that have been agreed, terms of the sale that have been agreed, sorry. In particular, ensuring you have appropriate warranties and indemnities drafted to minimise your risk is important. Our final key takeaway would be that regardless of if you're buying the business by way of a share sale or by way of an asset sale, there will be matters that need to occur in order for completion to take place and for you to become the owner of the shares or the assets, for example, a transfer of lease. Ensuring that your sale agreement details these requirements for completion will limit any issues you may have down the track. Now concludes the main part of our webinar. You might find our publication on buying a business in the UK useful. You can download it now by accessing the handout panel of this webinar or by scanning the QR code, which is now on your screen. So I'll just give you a moment to scan that code. Perfect. So we also have an upcoming event that may be of interest to you on cracking the due diligence code, insider tips for buying businesses. You can register for that at the link that is now on your slide. So if you just take that link there if needed. Okay, perfect. So we do have a bit of time to answer some of your questions that have been sent through, and also questions that you can send through now. So if you do send those questions through while you submit them, I'll take you through our membership, which you have a bit of an idea on your screen at the moment what that involves. So really, it's a cost-effective alternative to what you probably experience with other law firms, charging hourly rates for every matter that they do. So you could think of the membership like having your own in-house counsel. So we take care of all of the business's usual legal work and you can focus on the running of your business. So for an affordable monthly fee, you receive cost certainty and legal services that include those elements that you can see on your screen now. For example, you get unlimited document drafting and reviews, unlimited advice consultations with lawyers who specialise in their own areas. So we do have business structuring lawyers, employment, disputes, and general commercial lawyers. And you also get guaranteed quick turnarounds. So as a LegalVision member, you don't need to worry about the costs of lawyers ever again. If you want to learn more about how the membership can help you, you can request a free consultation when the survey appears at the end of this webinar. And now we'll answer some of your questions. So I think Sarah might take the first question there.
Yeah, so there was one that was submitted in advance, which I'll read out. So we are interested in acquiring a construction company. The company didn't disclose important information to us throughout, which we found out following our due diligence, resulting us to pull out. What steps can we take to avoid this in future? So I guess firstly, if you could still pull out, it sounds like you hadn't actually signed that legally binding sale contract yet. So it might have been the case, I'm assuming that you sort of did DD, maybe you thought you knew everything, then something else came to light and you kind of got cold feet and pulled out at that point, which does happen. So I guess this is why that due diligence process is so important, and also so important that it's run correctly. As lawyers, we're doing this day in, day out, so you can more easily identify where there are gaps in the information that's being given to you, or where we think maybe answers aren't kind of checking up properly, doesn't kind of seem like the seller's actually giving you everything that you need. So, ideally, that is why we also recommend that you don't sign that sale agreement until you're happy with your due diligence, because obviously at that point, that's when it becomes legally binding. You'll remember that Michaela was speaking you through the heads of terms earlier. So these typically aren't legally binding. They just set out kind of the proposed terms that the parties want to agree to, but they're not actually legally binding. So it's really that sale agreement, that's the point at which you get locked in. So obviously you want to make sure, you can pull out before then if there's still DD that you need to do, and you're not quite satisfied with everything. But yeah, as I said, I mean, really that's why getting advisors involved is quite important, because we can kind of check things off. There are also public searches that we can do. So, if the seller's answered a question to say, yeah, we own all of our IP, we can then actually do searches behind the scenes to make sure that does check out. So, again, it's sort of just that risk management piece to try and avoid any nasty surprises after.
Definitely. So I also have another question which was submitted before the webinar as well. So the question is, we run a real estate agency in Africa but want to expand and operate in the UK. What are our options? So really, I guess there's two main options that could be open to you. One would be to purchase an existing real estate agency in the UK, and that's where you need to be reaching out to your contacts, working out who's actually open to selling, and then following the process that we've set out in today's webinar. The other option that would be open to you would also be setting up a UK branch. So that could be, say, a subsidiary of your current, if you are operating as a company in Africa, it could be a subsidiary of that in the UK. Sarah and I actually also specialise in structuring of businesses, so we could advise you on the way to structure your business in order to actually establish in the UK. It really depends on your circumstances, whether you are looking to operate as a company, whether you're looking to just operate as your existing company but in the UK. And we can advise you on both of those options, whatever you would like to go down the path of. Yeah, so I think that answers that question.
Great. There's another one which asks, what is a normal period for a restrictive covenant or a non-compete clause imposed on a seller? So this will ultimately depend on the circumstances of the deal, looking at, how much impact could the seller have if they did open a competing business, focusing on things like the industry you're in and the location. So I guess the important thing to remember here is that a non-compete clause does need to be necessary to protect the goodwill of the business. So you can't go further than what's reasonably necessary to do that. So for example, if the seller was going to be setting up in Manchester and the business that you were buying was in London, it may not be reasonable to say that they can't do that if the sort of business you're running wouldn't have customers that are crossing across those two cities. Equally, it depends on the kind of business. So for example, if it was a restaurant that kind of wasn't doing anything particularly specific, it was just a restaurant or a pub, for example, and you're in a big city, there's restaurants and pubs everywhere, is it really going to be taking customers away from your business if the seller did then set up another pub or restaurant a couple of miles away? New ones are popping up all the time. So if it was something more specific, for example, I don't know, a vegan restaurant, you don't want someone else opening another vegan restaurant around the corner. That's legitimate to protect your business interest. So yeah, as you can see, it's going to very much depend on sort of location and what industry you are actually in. But kind of as a general response, I would say anywhere from 6 months up to the absolute max I've seen is sort of 3 years. But yeah, obviously that needs to be a very specific circumstance for that to be reasonable.
Definitely. Another question that's come through is, when should you usually be paying a deposit to purchase a business? So I guess the first thing to mention is in the UK in particular, deposits aren't generally required in the purchase of a business. The only time that you might actually be required to pay a deposit is if you've got the major asset of the business is actually property. So that's also where the deal is being brokered by a property manager. They might require a deposit in those circumstances. Otherwise, you generally won't be required to pay a deposit, but obviously it really depends on what the seller is requiring in terms of the actual sale. In terms of timing, when you actually need to pay a deposit, usually it would be when you exchange contracts. So what we were talking about earlier in terms of the process, you go through negotiating the sale contract. Once the parties agree on the terms of that contract, they then enter into an exchange process where they both sign, exchange contracts. At that point, there is then a legally binding contract between the two parties. And usually there's a clause in there that says when you exchange, the deposit is payable to the seller. Generally, you should also be looking to include a clause of what happens if completion doesn't occur. So completion is the step after you exchange contracts where both parties attend to the matters that need to occur in order for you to actually purchase the business. And if it doesn't go ahead for any reason, so for instance, in the instance the buyer is the one who is unable to complete, so a circumstance there would be if you can't come up with the rest of the purchase price, then generally the seller might be entitled to the deposit, but you really need to be drafting that clause to make sure that if, for instance, the seller was the one who wasn't able to complete or pulled out of the deal, that you actually are entitled to that deposit coming back to you. So it's important that you get those clauses right to make sure that you're protected, and if you are paying a deposit, that money is also protected as well.
Yeah, I've also often seen it actually where if there is a deposit, sometimes people put that in their heads of terms themselves. So that's obviously a bit more risky. It's not a legally binding document. So you want to make sure that the clauses about that deposit are the legally binding ones, so that, you know, as Michaela said, you are clear the circumstances in which you can get that deposit back, and you know that is legally binding. Because yeah, unfortunately, you do see that sometimes where then the deal falls through. You know, as someone said earlier, you know, they had to pull out after due diligence. If you'd paid a deposit at that point and you're pulling out because actually sort of what the sellers said about the business doesn't stack up, yeah, that's sort of on them. So you want that to be a circumstance where you can get your money back. So making sure there is some sort of agreement in place before you hand over that cash. So you are sort of protecting yourself there. I think we've got time for a couple more. So what are the possible options to buy a business when you may not have the full purchase price available in cash? So yeah, it's a really good question. We come across it quite a lot. So, you know, you can get a business loan if it's something that the bank's willing to lend you, or kind of peer-to-peer lending, and you sometimes see as well. But otherwise, it is fairly common, especially with larger purchase prices, for it to be kind of seller finance. So you might also hear it called vendor financing. So this is where, if as the buyer you don't have all of the money up front, you're almost agreeing the seller to kind of loan you the rest. And how this works is you'd pay a certain amount up front, and the rest would sort of be staggered out. So effectively, it's like the seller lending you that cash and letting you use the cash flow of the business to actually then, you know, pay them back. So you can also structure it by way of an earn-out if you wanted to do something like that. So it actually does tie in with how well the business is being, how well the business is doing after completion, and that then impacts how much the purchase price you're paying. But in this circumstance, we do recommend you have proper advice, because there are different ways to structure this that might have different consequences from a tax perspective. So obviously, if you're trying to fund this additional purchase price with business profits, and you have to declare a dividend to yourself first, and obviously the money's moved, so there may be tax consequences of doing that. So there are ways that you can structure it that are perhaps a bit more tax beneficial.
Definitely. So I think probably time for one more question. So this one is, you've spoken about warranties and indemnities being added to the sale agreement to protect against issues discovered during due diligence. Can you explain what a warranty is and what an indemnity is? So I guess warranties and indemnities are there to mitigate your risk. So when you are going through the due diligence process, there can be concerns that arise in the business. You also discover, I guess, the actual assets of the business, any other like contracts of the business, things like that. A warranty is something that you add into the sale contract where it's like a legally enforceable promise. So that's where they promise you, so the seller promises the buyer that a particular aspect of the business is as they say it is. So for instance, in the due diligence process, if they say that there are no employees of the business, a warranty in the sale contract might be that they warrant that there's no employees in the business as at the completion date or as at the date that you sign contracts. So whilst that's a warranty, you then have indemnities, which is sort of an add-on to that. So they're still a legally enforceable promise, but they operate a little bit differently. So they promise you that the seller will reimburse the buyer if something adverse happens. So that's where the seller is indemnifying the buyer in those instances. So I guess the main difference between the two, so that you're not getting confused, is around known issues. So for example, if something does come to light during due diligence, so it comes to light that there was a claim made by an existing employee, You would want a warranty in relation to this, but you could still be prevented from claiming on the basis that you were aware of the issue before completing. So if it arose during due diligence that there was a claim from an employee, and after completion, you then tried to make a claim for breach of warranty, well, make a claim back to the seller in relation to that, you would probably be prevented from making that claim just on the basis that you were aware of it during the due diligence process. That's why if something does come to light, you should also be looking to put in place an indemnity so that in that instance, after completion, you would actually be indemnified for the costs associated with that claim and for any damages, so that you can actually recover from the seller. I guess that's the two main differences between them. Yeah. Anything that you'd like to add on that, Sarah?
That highlights a good point as well, because you might also hear about the term disclosure process. So you've kind of got your due diligence process that the buyer will carry out before entering into the sale agreement typically, and then the seller will carry out its own disclosure process. So because you are asking for a list of warranties from the seller about the business, they will give those warranties to you, but it will be save as disclosed. So they might not be able to tell every single thing to you that is definitely true, because some of them might not be. You know, they might have a claim against them, so they can't give that warranty without any repercussions. So they will then disclose to you the instance that makes that warranty not true. And typically the two will match up. So they'll say, you know, you as the buyer have gone through this whole disclosure process, due diligence process. Off the back of that, you know, I populated this data room, you've got all of these documents. I know you've looked at them, so now I want to disclose those back to you, so that if anything in that data room would otherwise result in a breach of warranty, you now can't claim. Because, you know, let's say you've given them loads of documents about actually there was something slightly wrong with the accounts, and you don't want them to then buy the business from you and then claim because there's something wrong with the accounts, because everyone knew about that. And if there was a problem, the idea is you kind of negotiate that before you complete. So you might ask for a purchase price adjustment or something like that. So the two often go hand in hand. So you have your due diligence first, that's run by the buyer, and then you have your disclosure process that's run by the seller, which relates back to the warranties that are included. So yeah, the two go kind of hand in hand. Perfect. So I think that's probably all we have time for today, and I think we've now answered all the questions that have been submitted. So as I said at the beginning, a survey will now pop up when the webinar ends. So we're really grateful if you could submit any feedback. It's always good to know what you're liking, what you're not liking, what we can improve on. And if you do want that free consultation, then please make sure you pop in your contact details in that survey, and then we'll be in touch about giving you one of those complimentary legal consultations. Perfect. So thank you so much for joining us. I hope you have a lovely rest of your day.